Good morning, guys.
Yes, sir.
Both of you guys are charged with criminal cases. Both of you guys have worked out agreements with the state to plead guilty on those cases. What you guys need to understand is that they will end up on your record. They're going to be there for the rest of your life. You can never take it off. They're even there after you die. This is important because from now on, you will have minimums for any new cases that you pick up, if you pick up cases. So for both of you, Mr. Esquires, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine.
Whoa, this judge isn't sugarcoating it. A criminal record never goes away, even after death. That's a haunting reality check. For these defendants, future mistakes mean mandatory jail time. Think about it. Would you risk a plea deal knowing it sets a lifetime precedent? Drop a comment below.
The agreement you have is 3 days in jail, credit for the 6 that you've done. From now on, any new cases you pick up, you're looking at a minimum of 30 days in jail. Do you understand?
Sir.
Mr. Wardy, you're charged with assault causing bodily injury, and that's a Class A. You're facing up to a year in jail and or a $4,000 fine. You pick up any new cases from now on, that's a minimum of 90 days in jail. Do you understand?
Yes, sir.
Both of you guys are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, right to be arraigned, charged, read to in open court if you're not a citizen. There are possible immigration consequences. You can be deported, excluded from the country.
A year in jail and a $4,000 fine for assault. But here's the kicker. If he reoffends, it's an automatic 90-day minimum. The system's message, one strike and you're on a tightrope. Legal experts weigh in. Are these escalating penalties effective, or do they trap people in cycles of punishment?
Denied naturalization. How do you plead to the offense, Mr. Wardy?
Guilty.
How do you plead to the offense?
Guilty.
I'll find both of you guilty, sentence you to the time, and roll your court costs. Good luck to you.
Yes, sir. Thank you.
Get out to tonight.
Yes, sir.
We need you one.
Yes, sir.
Hi.
I'm here, Mr. Lumumba. I'm just asking for a reset. We just got an offer.
Okay.
See if there's something else we could do for him. So
They're getting quite up there. It's 150. So we'll give you a normal reset, but at the next time, we got to do something. Okay.
understand, Judge.
All right.
Thank you.
Got you. Have fun. Mr. Garris. How are you?
I'm doing very well, thank you. And I'm approaching on the Brandon Lane case. It's on your jail docket. And Mr. Lane, we had reset for 30 days so he could do the competency evaluation. In that meantime, my understanding is he got shipped off to Louisiana. So I don't think the competency evaluation.
Why would they do that?
Were there any offers?
When I talked to Helena,
God dog it.
and she's set for next week. And so, and also send a message to whoever is responsible for shipping to say, don't do that so we can accomplish this.
I got to figure that they probably just saw a long reset, and because of the overcrowding, they just,
I understand.
so, okay.
But I just, we try to solve the problem.
Right. Okay,
So my proposal is that we just reset it for late next week to see the.
whatever you want, whatever you want.
Okay. Thank you, Judge.
Okay, Mr. Garris. Mr. Barnes, you were charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Oh, Your Honor.
Can you go ahead and reach out, please, for Mr. Barnes?
Barnes?
This is the,
Oh.
Yeah, it was.
Okay. On April 8th, 2023, the officer was dispatched in reference to theft. The officer made contact with the complainant, the Walmart store manager, who stated that on April 7th, 2023, the defendant grabbed an iPhone 14 Pro Max, placed it under garments, walked to the men's room, and returned to the sales floor, where he passed all points of sale without attempting to purchase. The value of the item was $1,000.149, or $1,149, and the complainant stated that he went into the men's room and found the iPhone 14 casing and wrapper in a garbage can.
Hold up, this guy admitted to stealing an iPhone 14 Pro Max and hid it in the men's room. The store's audit caught him red-handed. But here's the real talk. At 22, with a sales job and a diploma, why risk it all for a phone? The judge's warning, build up, not down, hits hard. What would you tell him?
The complainant stated that they did an audit on the cell phones and noticed one missing. And the complainant stated the defendant was observed on surveillance taking the phone, and the defendant was brought into the office and questioned about the phone, where he admitted to taking the phone. The defendant further admitted to unwrapping the phone in the men's room and then taking it home. The officer made contact with the defendant, who repeated that he took the phone and passed all points of sale.
All right, Mr. Barnes, I'm going to find that there's probable cause to go forward with your case. I will give you a PR bond now, but if you pick up any more cases, you do anything else, no more. Do you understand?
Yes, sir.
How old are you, sir?
22.
Okay. What do you do for a living?
I'm a sales representative,
You
but
graduate
I don't
high
have.
school?
Sir? Yes,
Graduate
sir.
from high school?
Yes, sir.
Okay. Let's do this. I'm going to appoint you a lawyer today. As a condition of your bond, you're not to go to any Walmarts. Do you understand?
Sir.
Just be good. This is literally one of the worst that you can pick up, man. Really. You're 22. You're starting life now. You build yourself up, not down. The theft is.
This just took a dark turn. A second indecent exposure charge means 10 years on the sex offender registry and felony charges if he fails to comply. The stakes: deportation, barred citizenship, and lifelong stigma. True crime fans, sound off. Does this punishment fit the crime, or is the system stacking irreversible consequences?
You file, no going to Walmart.
Yes.
All right, so I'm going to have you sign a receipt of the Victoria, and then I'm going to have you take a seat, find your lawyer, okay? Please. Good morning, Mr. Bonilla.
Buenos días, señor Bonilla.
Mr. Bonilla, you are charged with indecent exposure. Is this a second indecent exposure?
Yes, sir.
We need that paperwork. This is very important, and you need to understand that from now on, because it's a second conviction, you will now have to register as a sex offender for 10 years. This is extremely important. If you fail to register on your release from jail, they can potentially file felony charges on you. Do you understand?
¿Usted lo entiende?
Es que decir sí o no. Yes.
Yes.
So we need him to sign paperwork reflecting that he's been admonished about the registration requirement. The agreement that you have worked out is 250 days in jail
Yes.
with credit for the 130 days that you have done.
Y ya sirvió.
You give up a lot of rights by entering into this agreement, Mr. Bonilla. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeals once you accept this agreement. You can never change this or undo this. Do you understand?
¿Usted lo entiende?
I understand this.
You still want to do this?
Yes.
How do you plead to the offense of indecent guilty or not guilty?
¿Culpable o no culpable?
Culpable.
Guilty.
I will find you guilty, sentence you to 250 days in jail, give you credit for the 130 days that you have done.
Ya sirvió.
I need to see if it's enhanced. It is enhanced. Or enhanced with a Class A misdemeanor assault out of Court 5 from February 6th of 24. Is it true? Is it true that you
¿Verdad?
had that prior assault?
Ese asalto previamente.
Did you have a prior assault with us here?
¿Y en esta corte?
Yes.
Yes.
So true to the enhancement. Is that it?
I'm gonna have them fill this out, the defense attorney has to go over and show this.
Okay, so Abel, we need you to go with this over with him so he can initial it. He initials by everything and then I'll sign it after the fact. Okay, all right.
This one judge has 2 cases, 1 lighted and 13 that should be coming in.
What time does court start, sir?
Court starts at, I just read the sign, 8:30, sir.
What time did you get here?
I got a felony court at 8 o'clock, sir.
Oh, you had felony court today?
Yes, sir. Excuse my absence, sir.
It's okay. I mean, if you had felony court, then I'm not gonna ding you.
Or 183 Judge Lang or something like that. Just been appointed January 1st.
So the one that's in 13 is getting transferred here? You've now picked up your 3rd case.
Yes, sir.
You were not, don't say anything. You're charged with possession of marijuana again. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. All right.
Your Honor, which possession case are we doing PC on, the one ending in 562 or the 962?
Let's do, 562. And then we'll do the other one right after.
Okay. On January 6, 2025, the officer conducted a traffic stop on the 3100 block of West Little York Road for the defendant's vehicle having a defective passenger tail light. And the officer made contact with the defendant, the driver, with a passenger. The defendant gave permission for the officer to search the vehicle. The officer observed a clear bag of green leafy substance which emitted an odor of marijuana between the passenger seat and the center console. The defendant admitted the bag was his and the substance was known to be marijuana based on training experience. The weight was 50.4 grams or 1.77 ounces.
You have a license. You say he was a driver?
He was the driver and the car had a defective passenger taillight.
Can you tell me if there's a valid license, please?
It's eligible, Your Honor.
Now let's do it on the new case, please.
Yes, Judge. So on January 10th, 2025, the officer stopped the vehicle.
The judge is fuming. This guy's laughing over his 3rd pot case? With possible bond revocation and jail time, it's no joke. But here's the irony. He's busted for a defective tail light twice. Is this bad luck or a sign to quit pushing his luck? Let's debate in the comments.
For a defective stop lamp, the officer made contact with the driver, and while trying to confirm the vehicle VIN from the front windshield, it was blocked with a white card. So he asked the driver if he could open the driver door to confirm the VIN number, and the defendant, the driver, agreed. And while the door was open, the officer saw a small bag of marijuana in the driver door compartment. The officer detained the defendant, and the weight of the marijuana was 0.289 ounces and was known to be marijuana based on training experience.
Stops today, Mr. Martin. I will test you 45 days from today. And if you test positive for marijuana, I'm going to revoke your bond and put you in. Do you understand?
Yes, sir.
No more smoking marijuana. I'm making it a condition of your bond. Do you need a court-appointed lawyer, sir?
Yes, sir, for right now.
Okay. I'll have you fill out an application. If you qualify, I will provide you a lawyer today. And let me make one more thing apprise you. If you pick up a 4th case, I'm going to go nuts. Do you understand, sir?
Yes, sir.
Your attitude is that like this is a big joke, but I don't know why you're laughing. It's not a funny matter. And, but
I have the right to speak?
no, don't.
Yes, sir.
You have the right to remain silent. I have a bunch of DAs here. Whatever you say, they're going to try to use it against you. I'm just trying to impart to you that a 3rd case, it's not a happy thing. Yeah.
Page 4, Birch, set for arraignment, first time, failed to appear.
Um, 4501.
Right, page 6, Judge, top of page 6. Was THA yesterday, he failed to appear, so I wrote it for today. He did show up. He's here. He was
Okay.
THA.
Come on up. Is that you? Is it Chappelle? Chapel, come on up. Good morning, Mr. Chapel. Do you have a lawyer today?
Sir,
Do you have a lawyer today?
I can't get caught upon that.
I'll have you fill out an application. I'll see whether you qualify and we'll go from there. Okay? Please.
It's just one. Judge, did you grant a license today?
No.
Next, Judge, is page 23.
5,002 on both. Okay, who's next? Vic?
Judge Smith. Page 36, Lopez.
Just waive it. Satisfy it.
Huh?
Just satisfy it.
Court 10 wants to know, would you like them to put stuff
In my queue.
Ooh, a media case, KPRC covered drama. The judge is being pressured to raise bail, but due process can't be rushed. Notice how he insists on the defendant's presence. That's the law in action. No backroom deals. True crime buffs, stay tuned. This sounds like it's about to blow up.